Hello, everyone, and welcome back. Before we continue on, I will remind you again that I am not a lawyer and I am not certified to practice law here in Vietnam. I'm just simply a foreigner from the United States who knows about the labor code. Now, we're going to go ahead and move on with the labor code, starting with Article 19, entering into multiple employment contracts. Now, the funny part about this is what I remember, somewhere in the labor code, it states that you can have up to 5 work permits. I don't know exactly where it's at, but I know it's in here somewhere that says you can have up to 5 work permits within a 2-year period. I'm going to have to find that. Anyways, Article 19, entering into multiple employment contracts. Clause 1, an employee may enter into employment contracts with more than one employer, as most English teachers do, provided that he or she fully performs all terms and conditions contained in the concluded contracts. Clause 2, where an employee enters into employment contracts with more than one employer, his or her participation in social insurance, health insurance, and unemployment insurance schemes shall comply with regulations of law on social insurance, health insurance, unemployment insurance, occupational safety, and health. Now, what this article means here is quite simple. Clause 1 states that, yes, you are allowed to work for multiple people. Now, for people that need work permits, you can have up to 5. That's it, no more, provided that you fully perform all terms and conditions contained in that contract, provided it's legal. Now, Clause 2 states that if you have multiple employers, that means you must also have multiple insurance schemes, social, health, and unemployment. And that means that all of them must synchronize together. I don't know exactly how you're supposed to do that, but it mentions it must comply with the regulations of law on social, health, unemployment, occupational safety, and health. So, yeah, I have all of that. I have all these laws. I just have to really look through it and find it. So, yeah. Anyways, moving on. Article 20. And again, as everybody knows, you have English here, Vietnamese here. The English here is just for reference only. The Vietnamese version is the part that you really need to pay attention to. Now, again, why I have both is because if someone who knows Vietnamese watches my videos, they can see that exactly everything I'm saying is true. So, moving on. Types of employment contracts. This is something that a lot of English centers do not understand because they think that, well, they think what they think. We'll just go ahead and leave it like that. Remember, YouTube and Vietnamese broadcasting policies prevent me from saying certain things online. And I have no problem with that. I do wish to comply with the rules. So, let's move on. Article 20, Types of Employment Contracts. Clause 1, an employment contract shall be concluded in one of the following types. Clause A, an indefinite term employment contract is a contract in which the two parties neither fix the term nor the time of termination of the contract. Simply put, start date only, no end date. Clause 1, subclause A, subclause A. There we go. B, a fixed term employment contract is a contract in which the two parties fix the term of the contract for a duration of up to 36 months from the date of its conclusion. So basically from whenever you start up to 3 years, which is 36 months. Now, here's the kicker. Clause 2. This is where a lot of employers, especially a lot of English centers, mess up. So if you weren't paying attention before, you should pay attention now. Clause 2. There we go. All right, now moving on. Clause 2. If an employee keeps working when an employment contract mentioned in point B, clause 1 of this article expires, point B, that clause A, within 30 days from the expiration of the employment contract, both parties shall conclude a new employment contract. Before such a new employment contract is concluded, the parties' rights, obligations, and interests specified in the old employment contract shall remain effective. So, essentially, if it's in the old contract, it'll remain effective. So, yeah. Now, essentially, within 30 days, a new employment contract should be concluded. But if it's not concluded, that's where subclause B comes in. Now, this is to prevent a lapse of an employment contract. That's what it means. That's to prevent a lapse. Because if you have a lapse of employment contract, especially for foreigners, that's going to cost a lot of money, and that's not something you want. So 30 days before your employment contract expires, your employer is required to give you a new employment contract, and if they don't, then that means they're trying to fish money out of you again. Yeah, that's all the English centers are about, is making money. Subclause B, if a new employment contract is not concluded after the 30-day period, The existing employment contract mentioned in point B, clause 1 of this article, as I showed you earlier, shall become an employment contract of indefinite term. Dun, dun, dun. This means that if your employment, this means that if your employment center, your English center, your job, whatever, if they do not give you a new employment contract after your old one expires, then that means your contract becomes one of indefinite term. It says so right there. And remember, Article 151, Clause 3 states that foreigners are protected by the Labor Code. This means this applies to them too. Oh, trust me, if you evil English centers don't hate me before, I'm sure you do now. That's okay, though. We'll keep going. Subclause C. The parties may enter into one more fixed-term employment contract, which is true. If the employee keeps working upon expiration of the second fixed-term employment contract, the third employment contract shall be of indefinite term, except for the employment contracts with directors of state-invested enterprises and the cases specified in Clause 1, Article 149, Clause 2, Article 151, and Clause 4, Article 177 of this Labor Code. Now, Article 149, if I remember, talks about elderly and youth. I think it talks about elderly or youth. Clause 2, Article 151, we're going to have to go back and look at that later. Anyways, so essentially what this whole article means, quite simply, is the fact that your employer is required by law to go ahead and renew your employment contract, and if they don't, and you still keep working for them past that period, then that means they are required by law to make it one of indefinite term, and if they don't, you can get them for breaching the Labor Code. Now, when I discuss the crime and punishment portion of this Labor Code, I can go ahead and tell you exactly how to report problems that you're having with your English center. I am taking a water break. One moment. All right, let's move on. We have about 17 minutes left. Yeah, I know, I'm still a little sick, but I feel a lot better than earlier. All right, moving on. Contents of the employment contracts. Now, remember everything that I have taught you so far, okay? All the videos that I put out so far about the Labor Code. Remember each and every one of them, because I'm going to go ahead and show you exactly why I showed you all that first before I showed you this. Article 21, Contents of Employment Contracts. Now, if your employment contract is missing any of this, in my opinion, not legal. So let's move on. Clause 1. An employment contract shall have the following major contents. Subclause A. Again, Subclause A, Subclause A. The employer's name, address, full name, and position of the person who concludes the contract on the employer's side. This means the person who is legally authorized to conclude employment contracts. Not just some employee, not a TA, not anybody else. The person that's actually authorized to hire people for the company. Subclause B, full name, date of birth, gender, residence, identity card, or passport number of the person who concludes the contract on the employee's side. There we go. The job and workplace. Job and workplace must be clearly specified in the employment contract. If they mention one workplace in your employment contract and you end up working somewhere else, in my opinion, that's illegal. Subclause D, duration of the employment contract. Usually it's listed as 1 year, but for English teachers, it's about 9 months. And then they have you on the roster for 3 months, not doing anything until they have you, sign a new employment contract, which in my opinion, that ain't right. If you want an English teacher to sign a year-long contract, you need to give them work for a whole year. That includes during the summer. Don't sign them up for a year-long contract, give them 9 months of work, and make them have off for 3. That's not cool. If you can't give them a year's worth of work, don't make them sign a year contract. Moving on, double D, marked with the D with a slash through it. Job or position-based salary. Job or position-based salary. Form of salary payment. Due date for payment of salary, allowances, and other additional payments. Now, I did go over this earlier in the video that talks about salary payment. Regimes for promotion and pay rise. Same thing. Working hours and rest periods. I know I covered that. Personal protective equipment for the employee. Now, here's the thing. I don't think I covered that yet, but in the laws on occupational safety and health, your employer is required by law to pay for PPE for you. Now, for English teachers, this could mean things like masks and hand sanitizer. Now, I know there's a lot of English teachers out there that think that their looks are more important than their students' health and safety, but I'll tell you this, when you get sick with COVID, you're going to think differently. I've been sick with it at least twice now that I know of, and I have got my shots, so that's the reason why I didn't land up in the hospital. Get your shots and mask up. There's no excuse. So, letter H, scrolling up. All right, now, I, Social Health and Unemployment Insurance, Article 168. Basic and Advanced Training and Occupational Skill Development. I know I mentioned that. I think that was under the gender equality laws, but I know I mentioned that somewhere. All right, now, moving on. So if it is missing any of this, you should really, really question whether or not you want to work for your employer, because it literally says so right there, Article 121, Clause 1, all of the subclauses. If it's missing any of this, I would be very, very worried about working for them. Just my opinion. Now, moving on. Subclause 2. If the employee's job is directly related to the business secret, technological know-how as prescribed by law, this means jobs like Lockheed Martin or Raytheon Technologies, things like that where they make very highly advanced weapons for the military. Yeah, that's what this means. Not working for an English center. There's really nothing secret about working for an English center. Everybody who's ever worked for an English center, even one day, knows how an English center works. So this doesn't apply. If any English center tries to make you sign an NDA or a non-disclosure agreement, yeah, that's not, it's a Western concept that really has no basis here in Vietnam. That's what a lawyer actually told me. Whether or not it's true is a different story. But yeah, that does not apply to teaching English. It is not Raytheon Technologies or Lockheed Martin or anything like that. So no. But moving on. I'm not going to have to read it again. Anyways, moving on. If the employee's job is directly related to the business secret, technological know-how as prescribed by law, the employer has the right to sign a written agreement with the employee on the content and duration of the protection of the business secret, technology know-how, and on the benefit and the compensation obligation in case of violation by the employee. Again, does not apply to English teachers. Moving on. Clause 3 also does not apply to English teachers, but I'm going to say it anyways. If the employee works in agriculture, forestry, fishery, or salt production, both parties may exclude some of the aforementioned contents and negotiate additional agreements on settlement in the case when the contract execution is affected by natural disaster, fire, or weather. Self-explanatory. Clause 4. The contents of the employment contract with an employee who is recruited to work as the director of a state-invested enterprise shall be stipulated by the government. Obviously. Clause 5. The Minister of Labor, War, Invalids, and Social Affairs elaborate clauses 1, 2, and 3 of this article. So they will elaborate that article later on. All right, now, annexes to employment contracts. Now, some of you may go ahead and have annexes on your employment contract. It is legal, but you need to figure out exactly what is and what isn't legal. So we're going to go ahead and move on. Article 22, annexes to employment contracts. An annex to an employment contract is an integral part of the employment contract and is as binding as the employment contract. Is as binding. Right there. Again, English, Vietnamese. Moving on. Clause 2. An annex to an employment contract may elaborate or amend certain contents of the employment contract and must not change. The duration of the employment contract must not change. That means the annex to the employment contract can't have a longer end date or a shorter end date than what the actual employment contract says. Where an annex to an employment contract elaborates the employment contract in a manner that leads to a different interpretation of the employment contract, the contents of the employment contract shall prevail. This means that if the annex tries to override the actual employment contract and it's not an amendment to, that means the employment contract itself shall prevail. Moving on. Where an annex amends certain contents of the employment contract, it should clearly state the amendments or additions and the date on which they take effect. And the date on which they take effect. So the annex itself, it has to be written very clearly, and it can go ahead and may elaborate or amend certain contents of the employment contract, but it can't go ahead and override the employment contract. Not only that, it has to state everything and the date on which they take effect. So if it has no date of effect, it's basically worthless. Again, in my opinion. Now, we have about 9 minutes left, so let's see how far we can get through this. Article 23, Effective Employment Contract. An employment contract takes effect as of the date on which the contract is concluded by the parties unless otherwise agreed by both parties or prescribed by law. Just going to throw that out there. Now, moving on. Article 24, Probation. A lot of English centers don't even know what this is. Now, some do, some don't. And I think that after this video, a lot more English centers will know about this, and they're actually going to try and do it because it's another way to save money. Yeah, it is. Trust me. I'll show you how. See, when you look at the labor code, you have to look at it from both the employee and the employer's perspective. Both aspects at once. And I know that some people can't think like that, and that's okay. But that's the reason why I think as both the employer and the employee. When I talk about the labor code, this way you know exactly what's what. Now, again, with me, you don't simply go from point A to point B. No, you go from point A to letter Q to square root of pi back to the planet Saturn, and then number 2. Anyways, I guess take a small drink break. All right, now, I am going to have to get more water before I start my next video. Anyways, Article 24, Probation. Right there, right there. All right, so an employer and an employee, Clause 1, may conclude the contents of the probation in the employment contract or enter into a separate probation contract. So, essentially what this means is that excuse me about that. Sorry about that. Excuse me. Anyways, move on. So, essentially what this means, you can okay, let's go ahead and start over. So, an employer and an employee may conclude the contents of the probation in the employment contract or into a separate probation contract. So, what this means is that you can include the probation contract into the regular employment contract or conclude a separate probation contract. Now, what this means, we'll just go ahead and move on. So, Clause 2. The probation contract must include the probation period and the content specified in points A, B, C, D, G, and H, Clause 1, Article 21 of this code. So everything we discussed in Article 21 has to be in there also. And the probation period. Now, the probation period for people with probation period is in Article 25. We'll just discuss that here in a minute. Clause 3. Probation is not allowed if the employee works under an employment contract with a duration of less than a month. So if you're working under an oral contract and your duration is less than 1 month, you don't need probation. Article 25, Probationary Period. The probationary period shall be negotiated by the parties on the basis of the nature and complexity of the job. Only one probationary period is allowed for a job, and the probation shall not exceed excuse me. Clause 1, 180 days for the position of enterprise executive prescribed by the law on enterprises, the law on management, and the use of state investment in enterprises. There we go. 60 days, Clause 2, for positions that require a junior college degree or above. So if an evil English center would want to actually apply the probationary contract, they can make you work probation for 2 months. Now, most say probation with full salary, but yeah, we'll discuss that here again. So 30 days, Clause 3, 30 days for positions that require a secondary vocational certificate, professional secondary school positions of or for technicians and skilled employees. Now, in my opinion, this could apply to English teachers as well, because of the fact that essentially positions for technicians and skilled employees. Technically, you are a skilled employee if you're an English teacher because you need 3 years of certified work experience to get a job. So I think it should be just 30 days, but some may try to do 60. And then 6 working days for other jobs. Now, probationary salary. if they want to go ahead and do this, this is the way for them to save money. The probationary salary, Article 26, probationary salary. The probationary salary shall be negotiated by both parties and shall not be lower than 85% of the offered salary. What this means is simple. If they were to go ahead and offer you probation as a term of your employment, they can go ahead and give you lower salary than what is offered for your full-time or part-time salary, but it must not be lower than 85% of the offered salary. So if they offer you lower than 85% of the salary for your probationary salary, don't take it. Now, Article 27, we have 4 minutes left. Let's see if we can get through this. Termination of the probationary period, right there. Moving on. Upon the expiry of the probationary period, the employer shall inform the employee of the probation result. If the result is satisfactory, the employer shall keep implementing the concluded employment contract, if there is one, or conclude the employment contract. If the result is not satisfactory, the employer may terminate the concluded employment contract or the probationary contract. What this means is simple. 1, your employer is required to tell you of the results. If it's satisfactory, then that means you just keep doing your job. Or or conclude the employment contract. If you sign a separate probationary contract, then you conclude the actual employment contract. Moving on. So that's what it means. And if it's not satisfactory, then the employer basically terminates your contract, and that's that. Now, here's the kicker right here. The thing about this is the fact that during the probationary period, either party has the right to terminate the concluded probation contract or employment contract without prior notice and compensation obligation. This is where they can get you. This is the biggest thing, one of the biggest things in this employment contract right here, is the fact that during this probationary period, the English Center can go ahead and terminate your contract and not pay you. That's what it says right there. Without prior notice and compensation obligation. Now, here's the thing. 1, it is fraud to do that, in my opinion, because we know that if the English Centers actually started doing this, then they would do this and basically get nothing but free labor. That's how it's fraud. Because if they intend to not pay the English teachers, that's fraud. So watch out for this. If they want you to work for 2 months, or if they want you to work and it's like been a month and you haven't been paid, yeah, I would start asking questions. Now, we have about 2 minutes left. We will go ahead and move on. Now, some of this stuff, I know it's super boring, but it's stuff you really need to know. I'm going to go ahead and read this last portion, and then we're going to go ahead and do some other stuff. So, Section 2, Performance of the Employment Contract, Article 28. Moving on. Performance of works under an employment contract. The works under an employment contract shall be performed by the employee who directly enters into the contract. The workplace shall be consistent with that indicated in the employment contract unless otherwise agreed upon by both parties. Now, please pay attention to that. The workplace shall be consistent. That means, again, that if you sign up for one place and they send you to a different place, that's not cool. If you didn't agree to that, also not cool. Must be agreed upon by both parties. Yeah. So, we've already gone ahead and talked about that. Next one I'm going to talk about is Article 29. This is important because it is mentioned in the other articles. We're going to go ahead and start to cut this short because I'm already at almost the 5-minute period. So, I'm going to go ahead and say this. I got less than 5 minutes left before I have to go ahead and publish this video, so I'm going to go ahead and say this. Here recently, I've been on Facebook a lot, and I go ahead and flag a lot of content. You'll go ahead and see me on Facebook a lot. Say hi. Seriously, say hi. Doesn't cost you nothing. Now, another thing I'm going to mention is that, just like I mentioned earlier in this video, please wear a mask, and please get vaccinated. If you don't believe in either one, you should leave Vietnam. Because just like during COVID, they will make you wear a mask and they will make you get your shot or else you can't go outside. Yeah, that's what they did last time, and I fully support that because that's what actually stopped the virus from spreading too much. Yeah, anti-maskers, anti-vaxxers don't need to be in Vietnam. That's my opinion. Now, just like I always say at the end of my videos, Please make sure to like, comment, subscribe, share videos, talk about me with your friends, all of that. If you want to donate to me, if you want to donate or, just give me some cash or some goods or services, go ahead and talk to me on Google, either Google email or Google chat at tuxedoshadow@gmail.com. If you want to join my Zalo group, if you're on Zalo here in Vietnam and you want to join my Zalo group, go ahead and click on that link that's in the description. And yeah, now just to let everybody know, I got no cash left and I really need donations a lot. So please consider donating to keep this channel running. Thank you.